So welcome everyone to the Module 4 live session for the Legal Ethics course. Our topic this week is the attorney's and the paralegal's duty of loyalty. And along with that duty is the duty to avoid a conflict of interest. Legal ethics. Well, what is legal ethics? It's the usage and customs among members of the legal profession involving their moral and professional duties toward one another, toward clients, toward the courts. Legal ethics is a branch of moral science which treats the duties which a member of the legal profession owes to the public, to the court, to other professionals, and to his or her clients. So one of our ethical obligations, Yolanda and Adrian, is to avoid conflict of interest. It's a term used in connection with public officials and fiduciaries in their relationships to matters of private interest or gain. Ethical problems connected therewith are covered by studies in most jurisdictions and by federal statutes at the federal level. Let's talk about the paralegals and the attorney's duty to avoid a conflict of interest. A lawyer has a duty of loyalty to the client and is prohibited from undertaking matters directly adverse to that client. So a lawyer may not act as an advocate against a client that the lawyer represents in some matter, even if it's an unrelated matter. So, Adrian, let's suppose that you represent client A. Client A is an insurance company that is being sued in a personal injury accident. Now, suppose client B would like to sue the insurance company for something completely unrelated, such as maybe the insurance company is operating out of a building as a tenant, and the landlord wants to evict the insurance company from that commercial property. You cannot represent the landlord in a lawsuit against the insurance company for breach of lease. Even if it's a separate case, you could not represent an adverse interest. So a lawyer may not act as an advocate against a client that the lawyer represents, even if the other matter is unrelated. A lawyer may not be adverse to a former client if the lawyer formerly represented the client. So once the lawyer in our example is done with the personal injury case and the lawyer is no longer representing the insurance company, the lawyer still cannot take a client that would be adverse to the former client. A lawyer may not be adverse to a former client if the lawyer formerly represented the client on the same or substantially related matter, or if the lawyer acquired confidences from the former client that could be used to the detriment of the former client. So, a lawyer could take a matter that would be adverse to a former client if nothing that the attorney learned during its representation of that former client would be at issue in the new case. The lawyer must consider whether the potential representation of a client will adversely affect his or her independent professional judgment in handling that client's case. So, for example, if you represent a client in a real estate transaction, if you work for a law firm that is representing a client in a real estate transaction, if you work as a paralegal, the attorney that you work for cannot purchase the property, okay? Because that would be self-dealing almost. That'd be a conflict of interest. If your law firm is representing a client in the sale of real estate, then neither the paralegal nor the lawyer can then turn around and buy that real estate. That'd be a conflict of interest. Hi, Megan. Hi, Adrian. Any questions or observations? Yes.
I do have a question on what you just said. Does that mean, like, if they did purchase it, could they go to jail for that?
No, it's not a crime. it would be a violation of their professional duties, and they
Okay.
could be sued in a civil lawsuit. A civil lawsuit for breach of fiduciary duty, for attorney malpractice, for negligence, for something like that, misrepresentation. The only time an attorney can go to jail would be the unauthorized practice of law in a jurisdiction where they're not licensed. Of course, they can go to jail for committing any crime, but most of the attorney-client relationship is civil, and it'll be handled civilly, and a lawyer will be sued in a civil court where tort damages are available. Damages for breach of contract might be available. Does that answer your question?
Yes, thank you.
You're welcome. Let's talk about the ABA Model Guideline 7 for the utilization of paralegal services. A lawyer shall take reasonable measures to prevent conflict of interest resulting from a paralegal's other employment. So maybe a paralegal is working at 2 law firms, or maybe a paralegal is working at law firm A and gets an offer to make more money at law firm B. Lawyers must ensure that paralegals are instructed to disclose an interest that could create an apparent or an actual conflict of interest. Lawyers must carefully examine the cases of imputed disqualifications based on the paralegal's prior employment and experience, analyzing the facts and the law in their state, because authorities and procedures are somewhat split on the approach. So, Adrian, let me give you an example. Let's suppose that you're working as a paralegal in Nevada and you're working for your sister, and you are involved in a land development case involving some contractors who have done a defective job and working on a construction site. So you decide that you're going to leave your sister's law firm and go work for law firm B because they'll pay you twice as much. Well, law firm B is also involved in a land use dispute involving the same contractors. Can you go work for law firm B?
I wouldn't think so. Um, I
No.
would say that's like a conflict of interest. Plus, my sister might kill me.
So yeah, you have 2 reasons why you couldn't do it. Your sister might kill you, and it's a conflict of interest. But that's only the law in Nevada. All right, let's change the scenario. Let's assume you're in Minnesota. Okay, you're in Minnesota, and you're working for a different law firm, not your sister's. You're working for law firm A, and at law firm A, you are working on a divorce case. You are representing the wife in a divorce case. You get more money. You get an offer to make more money at law firm B. You go to work for law firm B. Well, law firm B is representing the husband in the divorce case, and you're in Minnesota. Can you go work for law firm B?
If you're asking me, again, I don't think so because now I know what's going on with the wife, and that's not really fair to the husband. So I would say that's still a conflict of interest.
Okay. Well, the rule is different. In most jurisdictions, the conflict of interest is on a case-by-case basis. So what would have to happen is the law firm B would have to erect what's called an ethical wall to prevent you from accessing the files relating to that divorce case where they're representing the husband and you've previously represented the wife. But you can still go to work for law firm B as long as you stay away from that one case and that one case's file. So that's how the ethical wall works, and that works in every state except Nevada. And since most of you probably won't be working in Nevada, you don't have to worry about it. Nevada is just one of those situations where you cannot go and work for the second law firm, period. But everywhere else in the country, you can go to work for the law firm. You just can't work on that case, and you are not allowed to have access to that file. Any questions? So, when a paralegal changes employers, there's always a potential for a conflict of interest, especially if the paralegal is employed in a small state or practicing in a particular specialty. The current and future employer have a responsibility to take measures to ensure that any potential conflict of interest is recognized. The legal assistant must be warned not to divulge any information relative to the representation of a client at the former employer and not to be involved in any way in the case in which the legal assistant worked on in prior employment. Upon receipt of the legal assistant's resignation, the employer should advise the legal assistant that he or she should not disclose any information that you learned during your employment. Any questions about how that change of employment is handled? Megan, does that make sense?
Yes, that makes sense.
Okay, yeah, it's very, as long as you're not in Nevada, it's very simple. Let's talk about the paralegal's prior work on a case. A critical element when determining the impropriety of potential representation is to determine the paralegal's prior exposure to a case. It must be determined if the paralegal was exposed to confidential information, and if so, the result must be that the erection of an appropriate ethical wall that will separate the information from the paralegal. So when you get to the new law firm, you're just not exposed to those files. You don't have access to those files, or you might have a conflict of interest. You can work on any other case at your new law firm as long as you stay away from the case or two where you might have a conflict of interest. So let's talk about the ethical wall. Okay, ethical wall means the screening method implemented in order to protect a client from a conflict of interest. Prohibit the paralegal from having any connection with the case. Ban discussions with or the transfer of documents to or from the paralegal. Restrict access to files. And educate all members of the law firm as to the separation of the paralegal from that particular case where the paralegal has the conflict of interest. That's the ethical wall. And you do need to know that for the quiz. So let's review. The ethical wall is a screening method used to protect a client from a conflict of interest, prohibit the paralegal from having any connection to the matter, ban discussions with or the transfer of documents to or from the paralegal, restrict the paralegal's access to files where there might be a conflict of interest, and educate all members of the firm as to the separation of the paralegal from that case where there is a conflict of interest. That's the ethical wall. Any questions about how to erect an ethical wall? This will definitely be on the quiz, so you want to make sure that you review it before you take the quiz.
Actually, I do have a question. I know
Yes.
it's like the ethical wall is actually, I mean, it's not an actual literal wall, but how would you go about that? I mean, would you create, this is basically with the assignment as well, because I get the whole idea of the ethical wall, but I mean, would that just be like would you build it in a software? Would you put that in there? Would you not be able to give her passwords for things? I mean, I guess I'm just not, I get it. It's just, I don't know. It's, I don't know. I'm not explaining myself very well, but how would you go about doing
No,
that
you
if
are.
you, how would you do that if I was working with my sister and then went to another law firm, your law firm? How would you do that?
Okay. Well, what I would do is that physical files, I wish I had one here where I could pick it up, but I don't. I don't keep those anymore. The files that pertain to the case where you have the conflict of interest, like we were talking about the car accident or the divorce where you represented the wife. Yeah. So if I represent the husband at the new law firm, I just would not give you that file to work on. When I needed a paralegal, I would ask you to work on a different assignment and not that case. I would ask another paralegal named Yolanda to work on that case because Yolanda doesn't have a conflict of interest. So that is how you would actually carry out the ethical wall. So at the law firm B, your new employer, when we get together and talk about the divorce case where you have a conflict of interest, you would not be invited to come into that conversation. We would go into a meeting room with just a few people and talk about the case. We would ask a paralegal named Megan to help us out because Megan doesn't have a conflict of interest. And, in the event that there were some files relating to that divorce case where you have the conflict of interest, we might use a secured password, save those on a secured server, a different server that not everyone has access to. Does that make sense? Yes, it's mostly the attorney's duty to assign a paralegal to a case where they don't have a conflict of interest. And in Nevada, the paralegal just can't work for the entire law firm. But the other 49 states, you can still go work for the firm. You just don't work on that one single case where you have a conflict of interest, or any case where you have a conflict of interest. Okay, any other questions about the ethical wall, which is not a physical wall, as Adrian pointed out, it's a conceptual wall. It's a conceptual method, a process of protecting a paralegal from a conflict of interest and really protecting the client from being exposed to a conflict of interest by keeping a wall between the paralegal and the case or two where she might have a conflict of interest, allowing her to work on all other cases, just not the one where she has a conflict of interest. Any other questions? Great. Let's move on to deception and the duty of loyalty. Legal professionals have a duty of loyalty to their clients. There is also a prohibition against deceiving a tribunal or court. Once again, what is the image of lawyers on TV? What about Trump's lawyers? We saw a lot of that during his presidency. What is your opinion of any attorney who would represent Donald Trump? What do you think, Megan, Yolanda, Adrian? Is that an honest person? An attorney who would represent Donald Trump?
I think if he was his lawyer, it was his duty not to either if it was honest or not honest. And he was his lawyer, and he had, like you said, confidentiality. And regardless if the lawyer himself was honest or not, it's his job to get clients. And he went under oath to become a lawyer to defend either those individuals that were honest or not honest.
Okay, but what about deception? An attorney cannot mislead a court as to law or fact. So, for example, these lawsuits about saying maybe the president really won the election, if there is no legal basis for that and there's no factual basis, a lawyer would violate his or her duty
Right.
to the
Yes.
tribunal by arguing fake facts or arguing fake law or not disclosing law which is clearly adverse to the client's position. So I think, and that's why you saw so many employees and attorneys resign under Trump, right? Because it was compromising their own personal integrity to continue to argue or support baseless positions, right?
Correct.
So yeah, um, all politics aside, an attorney is not allowed to mislead a court as to law or fact. So if your client doesn't really have a case, it's really unethical for the lawyer to pretend that you do have a case, right? It's really unethical. So let's talk about that, the deception, okay? An attorney shall not do any of the following: offer evidence they know to be false. I mean, was there really a question about whether Joe Biden won the 2020 presidential candidacy? Was there a question about, was there really a numerical issue as to whether he got the most electoral votes? I don't think there was, you know. So for an attorney to represent Trump in court and say that, Trump was cheated out of the election, there's not really a lot of evidence to support that. And any evidence they would offer would be false, really, just looking at it objectively. So a lawyer is not allowed to offer false evidence. And that's why you will see lawyers quitting or resigning, refusing to represent a client. If they know that there's no basis in law or fact for a claim, they will quit. An attorney is not allowed to make a false statement to the court. Again, if you're representing someone for rape, for example, right? We know there are several sexual assault allegations against the president, and one case that comes to mind, the lawyers that represent Trump in his rape case, they're not allowed to make a false statement to the court. Makes it difficult to be an attorney representing a client that there's probable cause to believe that person has committed a crime. You can't offer any false evidence. You can't make a false statement to the court either. If you do, it's a violation of the rules of professional conduct. An attorney may not withhold to the court and opposing counsel judicial precedent that is unfavorable to the attorney's case. An example of this would be me walking into court, and let's say I'm representing McDonald's. Do you remember the cases about 10 or 15 years ago when people would go through the drive-through and order coffee and then either spill it on themselves, or when the McDonald's employee was passing the hot coffee out the window, it somehow got spilled in the customer's lap? Do you remember those cases? I think there was two. No, one was in New Mexico. Yeah.
Yes.
Okay. In the events, and this is something that you will learn in your tort law cases. If a strict liability or products liability or a negligence lawsuit is brought against a wealthy corporation like McDonald's and they're found to be grossly negligent, the plaintiff, the customer, can get punitive damages. So in that case, I think the jury awarded $10 million in punitive damages. Now, people think, well, that's not fair. The customer did not have $10 million worth of damage. She may have had even 100,000, but she did suffer some, second and third degree burns from the hot coffee being poured in her lap. She won the case. She got some kind of damages for, medical pain, suffering. But that $10 million award was to punish McDonald's. So those are punitive damages, and those are available to punish a defendant who's been grossly negligent. And the reason why is they're in a position to make that coffee cooler, to train employees not to serve hot coffee and not to dump it in customers' lap. So it's to encourage McDonald's not to be negligent. So that's the purpose of punitive damages. Now, if I was to go into court and I know I'm representing McDonald's in a hot coffee case, I'm not allowed to go into court and say, Your Honor, no punitive damages are available in this case. Why, Adrian, why can't I say that? Why can't I go into the court and tell the court McDonald's cannot pay any punitive damages, Your Honor?
Oh, well, because that would be a lie because they know they can afford it.
Exactly. It would be a lie in fact, and it would be a lie in law. Punitive damages are available against deep pockets and corporations who have committed wrong. And these manufacturers of Jeeps that roll over, other defective vehicles, Ford has manufactured and sold vehicles that caught on fire. Ford has also sold vehicles with defective airbags. Punitive damages are available in those cases to encourage the deep pocket to be safer in the future, to punish them for their wrong. And if attorney representing a corporation goes into court and says, Your Honor, no punitive damages should be awarded in this case, that's really failing to disclose judicial precedent that would be unfavorable, because the law says that punitive damages are available and the facts show that punitive damages are required. So again, an attorney is not allowed to go into court and tell a bunch of lies, period. Despite the image of lawyers on these TV shows and in the media, I've always felt that we're held to a higher standard of duty. I personally almost never lie. Maybe when I was a kid, I told a few fibs here and there to stay out late or something, but as an adult, I can tell you honestly here, I don't have to look from side to side or anything like that. I do not lie, period. I don't need to lie. Lying, it goes against my moral fabric. I do not lie. And an attorney is really not supposed to lie. We're supposed to be honest. And we have a duty not to deceive our clients and not to deceive co-counsel and not to deceive the court. These same rules apply to legal assistants and paralegals as well. Is there any question about this deception and the duty of loyalty? We're not allowed to deceive people. And I believe that's one of the reasons why so many people who worked for Trump resigned, because they did not want to continue the deception. Any comments, questions, observations? Lawyers really are not we're really not the people that they portray us to be on TV. Most attorneys that I know and have worked with, worked for, are very honest and hardworking and very dedicated. We also, like last week, I spent 2 days doing pro bono work. It's not always about money. In fact, for me, it's usually not about money. For me, it's about doing what I believe is actually right. And I know a lot of attorneys who do pro bono work, do things for the public good, and they volunteer, they donate, and they're not lying and deceiving. But that lying and deceiving, will sell more news stories and will sell more TV shows. And of course, there are some, prosecutors and public defenders are put into a position sometimes where they can't tell all of their clients' secrets, or they can't be completely forthcoming with facts about a client because of the duty of confidentiality and the attorney-client privilege. There are certainly going to be some situations where criminal attorneys, have some obligations that prevent them from being completely forthright with the court. But overall, lawyers are held to a higher standard, again, of morals than the rest of the population. Any questions about that? Concerns about this deception? No deception, no self-dealing, no taking advantage of clients in weak positions. We're not allowed to steal their money. If an attorney, accepts a deposit to work on a case, the attorney actually has to work on the case or give that money back. Okay. If you don't have any more questions, we'll go ahead and have our quiz review. So there is a quiz in Module 4. Here is what I think would be helpful to study before taking the quiz. 1, an ethical wall is a screening method implemented in order to protect a client from a conflict of interest based on, the paralegal's previous employment. An ethical screen sets up office procedures which safeguard client information and files from any employee of the law firm who has that conflict of interest. A paralegal employed by a law firm must fully comply with the implementation and the maintenance of the ethical wall in every instance in which a conflict of interest with the paralegal has been identified. Attorneys may represent clients with an adverse interest if each client gives written consent. So we didn't talk about that, but there are some instances where an attorney can represent a client with adverse interest. And in those instances, the attorney would have to make a complete and full disclosure to each client, and the clients would then have to agree to accept and waive that conflict of interest in writing. And this is discussed in your materials for Module 4. If the attorney is aware of a false statement of law or fact being presented to the court, the attorney has a duty to make the court aware of that false statement. And review model rules, professional conduct rule 1.7. That's the conflict of interest rule. So make sure you read rule 1.7 before you take the quiz. Any questions about what might be on the quiz? Adrian, Yolanda, Megan, do you feel like you're ready for the quiz? Adrian said never. I think if you spend 30 minutes to an hour reviewing the material that is on this list, reviewing the material that is presented in Module 4, certainly if you spend an hour doing that, I think you'll be ready for the quiz. I'm 100% sure. Review Model Rule 1.7, which is the conflict of interest rule. Study the stuff that's on this quiz review list, and you should be good to go. All right, let's talk about our written assignment for Module 4. It gives you a chance to use your skills about the ethical wall. So let's talk about some new employer ethics. In this scenario, you are employed at a large law firm. A new paralegal named Melissa was hired 2 months ago and has been working on cases during that time. It came to your supervising attorney's attention that Melissa previously worked at a competing law firm representing an opposing party in a matter that you're currently working on. Conflict of interest. So your supervising attorney has asked you to prepare an inter-office memo notifying the rest of the firm's attorneys about the conflict. So for this assignment, you should create a legal memo explaining the screening process that Melissa should undergo to ensure there are no other conflicts. Be sure to organize your answer around these bullets. The steps necessary to erect an ethical wall for the known conflict. 3, the ethical issues present, given the fact that the conflict was not disclosed before Melissa began working on the matter. So your memo should be organized into 3 sections where you have paragraphs answering these 3 questions that flow in a logical order. Your memo should be 2 to 3 pages, double spaced, proper formatting, spelling, and grammar. 3 primary legal sources. Adrian, what are primary legal sources?
That would be like statutes or law.
When we're talking about ethics, what is a primary legal source?
The model of the, oh my gosh, I'm tongue tied now. The ABA model
Yeah,
rules, NALA.
any of those model rules. Yes, ABA model rules, NALA model rules. Those are the rules, the guidelines that would be the primary legal sources. So case law, any statutes, state statutes or federal, and then those ethical rules and guidelines. So those are your 3 primary sources. Anything else that you read, essays about the law, commentary about the law, treatises about the law, that stuff's all out there and it's interesting. It is not a primary legal source. It is a secondary source because it's somebody talking about the rules, which makes it a secondary source. The rules themselves are the primary source. A treatise talking about and explaining the rules is a secondary source. So you need 3 primary legal sources. If you want to read secondary sources or cite to 1 or 2 of them, that's fine, but you still need 3 primary legal sources in your memo. And be sure to organize your memo again around these sections, the heading or the caption, facts, issues, answer to issue, reasoning or discussion, which is where you answer those 3 questions, and then your conclusion. And again, your facts can be described in 1 paragraph. The issues presented can be described in 3 sentences, 1, 2, 3. The answer to the issue could actually be combined with the issue itself. And then the reasoning or discussion should be the longest part of your memo, organized around those 3 questions. And then your conclusion is, again, a very short paragraph. So again, follow the Blue Book citation format, use MS Word and Lexis Advanced to prepare your memo and do your research. And this assignment is due next month, which is this Sunday, May 2nd. Any questions about that? It's almost next month. 2021 is marching along. So this is the end of our Module 4 live session. Thank you so much, Yolanda, Adrian, and Megan for attending the live session. If you have any questions or concerns, you can always reach out to me, reach out to a tutor.
Thank you.
Oh, you're welcome. And I will see you all in cyberspace. Bye.
There's no question, no live classroom?
No.
Okay.
No live
All right.
classroom question.
Okay, thank you. Have a good week.
Thank you.